Good morning, everyone. This is our first panel. I would like myself to thank the organizers for the invitation to moderate this early in the day panel. So everyone will be still standing when we finish, I hope so. So the first panel is about the socioeconomic and political framework of the Lausanne Treaty. We will be starting with Mr. Evanthis Hatzivassiliou, Professor of Postwar History at the National and Kapodistrian University of Athens, Secretary General of the Hellenic Parliament Foundation for Parliamentarism and Democracy. And he's going to talk about the Treaty of Lausanne and the new international legitimacy. So I just would like to note to our speakers that we have 10 minutes, everyone. So stay in the framework. Thank you.
So this was a fair warning. Thank you, Mr. Chairman. Ladies and gentlemen, the peace settlement following the First World War, including the Treaty of Lausanne, created a novel international legitimacy as an integral part of a new value-oriented liberal international system. The new order was shaped by liberal forces and personalities, Woodrow Wilson, Georges Clemenceau, David Lloyd George. Namely, it was shaped by those who were the last to have been left standing after the conflict of 1914 to 18. By that time, the forces of aristocratic authoritarianism, Germany, Tsarist Russia, Austria-Hungary had been defeated, while the new authoritarianism of Soviet Russia had not yet fully emerged and had not yet fully joined the international system. There's no need to idealize the process. During the peace conferences, there were visible differences between, or misconceptions of, the three great victors, from the somehow idealistic internationalism of Woodrow Wilson to the crude realism of the two older great powers and the panic of France in the prospect of having to face Germany again in the future, perhaps this time alone. During the negotiations, many solutions were reached that were excessively complicated, self-defeating, or even unworkable, and many mistakes were committed. For example, the unjust and irrational clause of exclusive German guilt for the war, the partial implementation of the principle of self-determination in Eastern Europe, usually against the vanquished, and the fact that the humiliated Germany still retained its potential for a spectacular comeback as a wounded and angry great power. There was also a major, perhaps fatal, weakness of the cornerstone of the new order, the League of Nations. The League was not joined by the most powerful states of the globe, the US, Soviet Russia, and Germany, and was thus born geopolitically crippled. As often happens in international processes, diplomats simply got lost in the labyrinths of the issues they had to settle, and finally reached settlements that were not fully rational, especially in terms of local circumstances. Even so, the peace treaties represented a radical new start in international affairs. This was largely based on the 14 points proposed by the profoundly liberal leader of the greatest power in the globe, Woodrow Wilson. It is important to point to some of the salient features of this new order. First of all, the implementation of the principle of self-determination in East Central Europe, which signaled the definite transition from the empire to the nation-state, at least in Europe. Second, on the other hand, the proliferation of the institution of the nation-state was combined with an equally necessary move towards multilateralism. International organization based on sovereign equality of all the members of the international community took a giant step forward with the making of the League of Nations. These developments signaled significant breaks with the past. The imperial order of reactionary great powers was replaced with a new international legitimacy based on the liberal democratic principle of ethnicity. Forms of international organization existed in previous periods as well, but those were processes for great powers only. The European concept of the 19th century was a gathering of great powers, where small states were treated as inferior subalterns. Thus, in an international conference of the 19th century, small states were not really admitted into the discussions. Their representatives might be allowed to submit a memorandum and then sit outside the room and anxiously wait while the mighty great powers decided issues of life and death for their nations. This was what happened, for example, in the Berlin Conference of 1878, which decided the map of the Balkans. The Greeks were only allowed to submit a paper, and the Bulgarians, who were yet stateless, were not allowed to come at all. But the new concept of sovereign equality, embodied in the League of Nations, gave small states the right to participate in international processes. In my view, this alone should be enough for the name of Woodrow Wilson to be written with gold letters in the history of international relations, leaving aside today's criticism, which are being put forward with hindsight and, in my view, with an unbearable presentism by people determined to evaluate Wilson as if he were a... Okay, the problem is that many people, as you may know, Woodrow Wilson made a huge contribution in the evolution of the international system, although many people today criticize him. They try to evaluate him as if he were a saint, really, not as if he were a president. This post-1919 settlement was much more tenable and legitimized compared to previous eras when whole provinces could be given as dowry to the happy brides of the European high aristocracy, who reputedly, at least, thought that if the third estate did not have bread, they could eat cake. In other words, the peace settlement was a development of huge historical proportions. It meant, in international affairs, the end of the enormous conflict between aristocratic and liberal ideas, a conflict that had been raging in Europe since the late Middle Ages. This conflict was now decided definitely in favor of modernism and liberalism. And this international legitimacy sustained the full-scale attack of the forces of revisionism, most prominently Nazi Germany in the interwar period, but its concept triumphed during the Second World War. Now, the Treaty of Lausanne was an integral part of the new international order and legitimacy. It is true that one of its internal components included the shameful compulsory exchange of populations between Greece and Turkey. In other words, the elimination of minorities in one stroke. However, it is important to note that this exchange convention was decided after the violent expulsion of the Greeks from Western Asia Minor and distant Thrace had already taken place. In other words, the exchange convention did not effect the exchange itself, it simply concluded it, but of course still remains a shameful arrangement. At any rate, the definite, though sudden and violent, transition of the region from imperial governance to the model of the nation-state, the end of the Greek Megali Idea, the transformation of Turkey into a nation-state, and the definite settlement of the borders, at least in the Balkans, meant that Lausanne became the pillar of the new international legitimacy in the Near East. Allow me briefly to note the consequences of this development for Greek policy in particular. Greece had been a revisionist country until 1922. In the 19th century, Greece was one of the liberal small nations that were trying to question the imperial aristocratic reactionary legitimacy of that previous order. Under Venizelos, in the Paris Peace Conference, Greece distinguished itself in the making of this new liberal regime. Its defeat in Asia Minor and the expulsion of the Greeks from Turkey meant that the end of the Megali Idea came suddenly, violently, traumatically, but Greece's substantial enlargement following the Balkan Wars and the First World War meant that the territorial settlement was still acceptable to Athens, even if its Asia Minor endeavor had collapsed. So from 1923 onwards, Greece accepted the new liberal international order. It made courageous steps in embracing it, most notably the spectacular rapprochement with Turkey in 1930. In the fatal clash between legitimacy and revisionism in Europe during the second half of the 1930s, Greece took the side of legitimacy and persisted in this choice when facing the Axis invasions of 1940 and 1941. After the war, this fundamental option of the Greek state pushed it to the Western option and its participation in European unification. In other words, the acceptance of the Treaty of Lausanne was the basis for Greek policy in the century that followed, even until today. To conclude, my argument is that the Treaty of Lausanne is not only a regional arrangement. It was and still is the pillar of the liberal international system in this part of the world, and thus had and still has wider roles and significance in global affairs as well. This is the reason that, in my view, Lausanne remains as one of the cornerstones of international affairs of our time. Thank you.
Professor Hatzivassiliou, thanks for staying within time. And after describing us that transition in the international order system, you also made a bridge for our next speaker, Konstantinos Tsitselikis, who is a professor in international human rights law and the dean of the School of Economic and Regional Studies in the University of Macedonia. And he will present some slides also. His announcement is turning the page, the Greek-Turkish population exchange as a legal paradigm of constituent violence.
Thank you very much. Dear friends and colleagues, it's a great pleasure to be here for this conference. We have been attending a lot of conferences of this kind in the past 18 months, but I think this is one of the highest level. And I'm very glad to be here with Turkish colleagues from Turkey also, good friends from the past. We have discussing this for the past 25 years, and it's a good opportunity to reopen the discussion here today. So, of course, one among other issues, as the previous speaker said, is the population change that was accommodated within the framework of the Lausanne conference. It's important to remember that, of course, we have, in this period of time, in the past 12 years, before 1923, can I see the slides? Okay. So we had waves of wars, different wars. We have waves of forced or semi-forced population movements in the area, from the Greek kingdom to the Ottoman Empire, from the Ottoman Empire to the Greek kingdom, and elsewhere, of course, even to America or to Egypt or elsewhere. So we have to distinguish this period of time from the Balkan Wars and the Greek-Turkish War, and what happened after and during the Lausanne conference. So, what was at stake, of course, was sovereignty and the borders. And the quest for national territory in the nation, for Greece, of course, because as you said, this was a revisionist state that wanted to change in the past century and did it successfully. And this was the end of the successful line of changing territory and acquisition of populations. The main question for them then was, what was the nation, the Greek nation about? And this, of course, an important issue here, the end of this line. And then they decided, as you know, in January, 6 months before the end of the Lausanne conference, and this is important to reframe, to exchange populations on the basis of religion. This was one thing. And the most important thing was, of course, to exchange population on a mandatory way. So this was the point here. Then, what we can say that we had a mutual transfer of objects. So we don't have the idea of individuals who were given the option to move to a new country, to a new homeland, but the states decided to do the transfer. So the mutual deportation, because we are talking about deportation in fact, of own citizens was internationally acceptable, was legally regulated, and carried out through international cooperation, through the mixed commissions, as you know. And here, of course, we have an expression of absolute state voluntariness. So here we have a kind of contradiction, because already we have the idea of protection of minorities, and here again we have the elimination of minorities through law, but at the same time 6 months later, by the chapter on minorities in the Treaty of Lausanne, we have the protection of minorities again for those who have been exempted. Again, I lost control of my... So finally, as you know, I'm not going to go into details, all actors at the Conference of Lausanne finally supported the idea of the mandatory population exchange, of course not with the same enthusiasm. There were, of course, big discussions. But it's interesting to know that the actors were not, I know there's a panel on this, they had different ideas a few years ago, like Venizelos, who in 1906, before the Cretan Parliament, were saying that Greece one day will become an important Muslim power, like France or Russia. And Venizelos was the one who had established a sophisticated minority protection. And Venizelos, who were, even after the Treaty of Lausanne, was a very fervent discussant under the auspices of the League of Nations in favor of the new minority protection era. Here, I would like to mention Nicholas Politis, one of the most eminent international law lawyers, scholars, and diplomats, who a few years later supported in 1940 the idea of population transfers and even the refoulement of Jews committed by the Nazis, and this was done before a French audience in Paris, saying that the end of the minorities are the only solution to achieve peace in Europe. And he made that reference to Hitler also. I call this from Dimitris Dimoulis, who refers to Politis as the enemy of the Constitution. And I'm coming to come back to this. So what happened, as you know very well, 1.3 million Greek Orthodox or so, and less than 400,000 Muslims lost home, work, property, citizenship, and members of their families. The violation of rights, personal autonomy, personal security, development, property rights movement, and religious freedom, because they were not allowed to change religion anymore by the treaty. So the question here is, do you have a breach of constitutional legal framework and international law? Or is it an anachronism if we say today, under the framework of human rights, and we displace it to the past? Here, just to remember again, mapping those who have been transferred, you can see from both countries where they have been settled, those who had to be transferred or deported or exchanged to the other new home country, and those who have been exempted by the Treaty of Lausanne, and those who have been exempted because very often we don't remember them, those who have been exempted extra-conventionally 18 months later. So the Albanians in Greece and the Arabs in Turkey. Let's see now what the Greek, among others, but especially the Greek scholars, were saying just after the population exchange. I will go very fast. Tenekidis. I don't know what they were because I'm pretty sure you know their CVs, saying that the mandatory character of the Convention of Lausanne is odious and against international law. Keseo, in a PhD in Paris, said that the convention is null and void. It's a regression of international law and brings medieval barbarism to Europe. Seferiadis, in a lecture in the Harvard Academy, said that the Convention of Lausanne violates fundamental norms of international law. Another PhD is saying, Leondiadis in a German journal said the same things, that by not protecting the law of citizenship were violated. And Straits is important, used for the first time, to my knowledge, is not known, the term ethnic cleansing in Germany for the population exchange. And he said that this constituted a crime against humanity. Ladas then brings the idea of raison d'etat, and I think after Ladas, the literature follows this path of raison d'etat above human rights and the individual. And to come to my conclusions, so of course the Treaty of Lausanne closed the pending issues after the First World War, was a realpolitik of the time, but the devastating results of the Greek-Turkish War were coupled finally by the humanitarian disaster brought by the population exchange. And then we have an ethnic cleansing as constituent for both Greece and Turkey. So this violence was endorsed by national and international law and as an acceptable legal paradigm, even if at the time all these eminent scholars were saying the opposite. Don't ask, because the discussion about the legal effects of a possibility to declare the Convention of Lausanne as against contra-legging would be another topic. I'm not going to touch this. Of course, we don't have any legal effect today. And this was answered by the European Court of Human Rights, you remember, I think 20 years ago, for another occasion. So I would say that the population exchange, according to the then standards, violated constitutional and international law. It would be a very interesting discussion to see the constitutional framework of human rights at that time. In Greece it's more established, but in Turkey it's more fluid. It would be very interesting to see what would be the constitutional order in Turkey, 1920-23. So what I would say that modernity was freed for a moment. Individuals lost their human quality and rights, and it was defrosted a few months later. So they became again citizens. So international law and constitutional law restarted accordingly, but after being violated. So I would say in 20 seconds that we had in the past monologues in both Greece and Turkey, and I'm very glad we are all together here, and in other only other three conferences where we meet and exchange ideas. We had a silence in the past century about these topics under the raison d'etat logic, and I would like to reopen this discussion about the values of ethnic, linguistic, and religious coexistence as foundations of a modern pluralistic and humanized democracies where the individual has the central place. Thank you very much.
Thank you, Professor Tsitselikis, for this insightful announcement, and I think that your final comment is very useful on how Greek and Turkish academics and the civil society can discuss on issues emanating from the Treaty of Lausanne that somehow regulate the relationship between the two countries for the last century. Now, our next speaker is Esra Ünal. She's a visiting lecturer of public international law at Kadir University and a postdoctoral researcher at the National and Kapodistrian University of Athens. She will be she will be presenting an assessment of the Lausanne cases and an analysis of the statistical data related to the cases on the Treaty of Lausanne filed before the domestic courts.
Yeah, thank you very much. Good morning. I feel so privileged and I'm so honored to be with all of you here in this very important event in the 100th anniversary of the Treaty of Lausanne, especially with my doctorate thesis supervisor and my master thesis supervisor, with distinguished speakers who I benefit from their works all the time. When I first received the conference invitation, I was immediately excited to prepare something related to the recent situation of the application of the Treaty of Lausanne, but what should I have presented and how could I make contribution to this very important conference? Actually, my presentation is about the significance of the Treaty of Lausanne, and it's intended to provide an analysis of the statistical data related to the cases on the Treaty of Lausanne filed before the domestic courts that were extracted from various domestic case law databases in Greece and in Turkey, like Domos and Jurix or Kazancı. Unfortunately, there is no access to all cases and decisions, especially of courts of first instances. I find this endeavor important because domestic courts of both countries for years took decisions in line with the government's applications. Even for the European rights system, human rights system, the primary responsibility to ensure the application and effective implementation of the convention lies with the state parties and national authorities, and in particular courts, so which are the first guardians of human rights, and states are the ones which will ensure the application in accordance with the principle of subsidiarity. I think I don't have my presentation, but it's okay if you don't have that. Actually, this is like presenting the previous accounting period and detecting the issues and what has been changed in 100 years. It's not an easy task, but this is an appropriate way to support individuals, practitioners, judges in exploring innovative strategies to advance the protection of rights and bring forward new reforms at national level. Here we are referring to a 100-year-old international treaty which is still in force today, and of course evaluating the past with today's mentality can lead us pedantic judgmentalism, but in the context of an international treaty which is still being referred to, parties to this treaty are compelled to reconciliation with new developments in the international system. Despite the fact that there is the same international treaty, one treaty, the interpretation and implementation of the provisions and the subjects of the cases vary. Therefore, it's more important to assess whether and to what extent they are compatible with the international standards and ensure the promotion of human rights in these states. The approach must make it possible to accurately and systematically identify the legal areas where international standards are met, those who are not met, and where reforms are needed. A research makes sense if it relies on a trend, and we have to look at the statistics. What is the trend over there? At the end, we can establish a cause and effect relationship. My data is case law, not legislation. I have worked on these cases that they are related to the Treaty of Lausanne and the exchange of population, and I make groups according to years and clusters according to the subjects. I have worked on almost 150 cases, and if the clusters are the same, I divided the case law according to the states to show their different approaches and subclusters for different types of courts and years. For instance, there's a cluster on the territorial application of the Treaty of Lausanne. Here, cases related to Antioquia from Turkey or cases related to the rest of Greece other than Western Thrace are in the same cluster with different subgroups. Sometimes, not in the context of the decision, but in the dissenting opinions we see a discussion on the Treaty of Lausanne, and I didn't include this into the data. Accordingly, there are decisions which are not related directly to the treaty, and only the names are pronounced. I didn't include them into the data as well. And finally, I made a separate cluster for cases that the Treaty of Lausanne is relatively elaborated in detail, despite the fact that the main case is not about the treaty at all. But since there's a pronouncement of the opinion of the treaty, I wanted to make a separate cluster for different types of courts. So, Treaty of Lausanne is crucial, both for Greece and Turkey, especially since the establishment of the Republic. The treaty has been seen as the founding international legal instrument. We see that all high courts in Turkey place Lausanne at the top of the hierarchy of legal norms in the Turkish constitutional system. Apart from the question of to what degree the Lausanne minority provisions are implemented, states rely on the treaty in every instance when the protection of minority rights is at issue. Also, as you know, Article 37 of the treaty states that the stipulations contained in shall be recognized as fundamental laws. However, this only covers articles between 38 and 45 in this sense. Basically, for Greece, we see a three-tier system for the domestic court system, and also after the amendments, Turkey also has a three-tier system, but now Turkey has also the constitutional court with the individual application. And I would like to give you the example from the Constitutional Court of Turkey. For this research, three different types of case law concern us: the review of norms, the constitutional complaint, individual applications, and dissolution of political parties. I'm referring to the example of the Constitutional Court. In connection with Professor Dr. Tsitselikis' presentation, I can give you an example about one case about the exchange of population, for instance, regarding the review of norms. There is a case on the abandoned properties, and this is still an issue because here the person must prove the property was not abandoned before the Council of State. If we assume that the lawsuit is initiated within the period, he or she should provide the official documents that not only himself but those in the inheritance list were not fugitive. Then he or she has to find birth certificates, and then this is not sufficient to acquire the property. Then he or she has to initiate a lawsuit to a civil court and have a registration decision in his or her favor. Also, this is a right only provided to people who left the country after the Treaty of Lausanne, which means people who are not subject to abandoned property laws. Another one is the individual application, which started in 2012. The jurisdiction of the court comprises fundamental rights and liberties which are enshrined by both the Constitution and the European Convention on Human Rights. Again, there's an interesting case here. It's in the application of İhsan Rucuoğlu, the applicant argued that, I'm speaking about the Turkish Constitutional Court, the applicant argued that his deceased came to Turkey from Greece in 1924 and was given a property in Safranbolu in Turkey. This is another case. So another one is the dissolution of parties, where Constitutional Court see the issues of minorities in Turkey as regulated Treaty of Lausanne. So it's not only locked in just the property issues or the Pius Foundation issues. We see the Treaty of Lausanne in many parts of the court systems. So I have determined 15 clusters so far, but of course the case law is improving, and it gives some insight into the extent to which the subjects are problematic and need to be studied, like the Constitutional Court party closure cases or deprivation of nationality from Greece, reciprocity cases on cadastre, especially for the certificates of inheritance cases, we know, expropriation and confiscation cases. Here we saw a slowly a change, a development of the case law in line with the European Court of Human Rights, Pius foundations, legal personality of religious communities, election of the religious leaders, elected mufti and appointed mufti from Greece, education of clergy. So in conclusion, the Treaty of Lausanne is not the only treaty that states are parties, and the European Convention on Human Rights is a project for changing and transforming the people through the law. And the Treaty of Lausanne has to be applied in harmony with the European Convention on Human Rights. What can be done? For instance, as per Protocol 16 to the Convention, it allows the highest courts and tribunals of a state party to request the court to give advisory opinion, or the Turkish Constitutional Court, for instance, maintains a constant institutional contact with national and international courts. Like they have 27 memoranda of understanding with other constitutional courts and Supreme Courts in order to enhance the bilateral cooperation activities, for instance, Bulgaria, Romania, Montenegro in 2012. So this can be done in order to work on the case law. Thank you very much.
Thank you for your speech. Now we will go into our keynote speaker, Professor of Economics and Economic History at Bogaziçi University, Şevket Pamuk, who will be online, already is online I think. and he will give a speech on the economic consequences of the Treaty of Lausanne.
Good morning.
You hear us, Professor Pamuk? You must commence.
Good morning. I thank the organizers for the invitation. I must add, I am especially honored to participate in this conference because every schoolboy in Turkey, at least of my generation, has been taught that the Lausanne Treaty is the cornerstone of modern Turkey. I will be focusing on the economic issues at Lausanne. There were many economic issues that were discussed, including insurance issues, intellectual property issues, properties of corporations, and what have you. But I have decided to focus on three most important issues for Turkey. These are economic issues concerning Turkey and the European countries. And I will also focus on the economic dimensions of the population exchange between Turkey and Greece. And I will try to touch both the negotiations, the content of the negotiations in Lausanne, and also emphasize the long-term consequences. Now, the three key economic issues that I have identified that were discussed at Lausanne were the Ottoman debt, commercial policy for the emerging state of Turkey, and the status of the privileges for European citizens. Now, each one of these three issues had roots in the Ottoman era, in the 19th century, but in some cases even before the 19th century. In each of these three issues, I might add that these were each one of these were very contentious issues, and they were discussed extensively at Lausanne. The overriding goal for Ankara was sovereignty and the construction of a national economy. The Ottoman debt goes back to the middle of the 19th century. The Ottoman government kept on accumulating large deficits, and these deficits had to be financed by external borrowing. At Lausanne, a lot of time was spent on dividing up the outstanding Ottoman debt between successor states. There was also a great deal of discussion on whether the payments would be made in gold or in paper currency. And final decisions on the Ottoman debt were really not taken by the time the treaty was signed in July 1923. Negotiations continued until 1927, and a final decision was made with the Paris Agreement in 1927. And according to the Paris Agreement, Turkey, as well as the other successor states, were to begin payments on the outstanding Ottoman debt in 1929. However, just as Turkey and other successor states began making payments, the Great Depression started. So Turkey, as well as others, demanded a renegotiation because of the Great Depression, yet another round of negotiations that lasted until 1933. So Turkey, which had assumed about 67% of the outstanding debt, was able to substantially reduce payments on the Ottoman debt after 1930 as a result of this second round of negotiations. Equally important, perhaps more important for long-term economic development in Turkey was the commercial policy. The idea that the new emerging state of Turkey wanted to have the power to establish its own commercial policy, including tariffs. This problem goes back to the free trade treaties the Ottoman Empire, Ottoman government signed in 1838. These were bilateral treaties, so the Ottoman government bound itself not to change these free trade treaties without the consent and agreement of the European states. So Ottoman government was unable to raise tariffs, was unable to pursue a policy of industrialization during the 19th century. At Lausanne, the new state, after long negotiations and contentious negotiations, I might add, the new state obtained the right to establish new tariffs beginning in the year 1929. And this right remained the cornerstone of Turkish economic policy until 1980. A good part of Turkey's industrialization, beginning in 1930 and lasting until 1980, was based explicitly on protectionism and higher tariffs. So what the new state obtained the right to establish its own tariffs was extremely important for economic development and economic policy in the subsequent half century. The third major issue at Lausanne was the privileges of European citizens, fiscal and legal privileges, what are in Turkish parlance and Italy's parlance is the capitulations that go back way back to the Middle Ages in the Eastern Mediterranean. By the 19th century and the 20th century, the privilege for the citizens of European states had become a major source of disadvantage for the Ottoman citizens. And I might add that some Ottoman citizens, including Greek-speaking Ottoman citizens, had opted to use these capitulations by applying to European embassies and obtaining special documents. So, as in the commercial policy, there was long negotiations, but the new state in Ankara was able to obtain the right to eliminate all these privileges. So, if I were to summarize these three key economic issues at Lausanne, these three issues had defined the character of the Ottoman economy in the 19th century. These three issues had defined an open economy with advantages for European states and their citizens. What the new government in Ankara did at Lausanne was to fight for full sovereignty, for elimination of these privileges for citizens of other states, and also for the right for the new state to establish its own tariffs and commercial policy. And basically, Ankara was successful in these negotiations, and the new state obtained all these rights, which proved to be very important for the construction of a national economy beginning in 1930. And for the rest of the 20th century, these rights obtained in Lausanne proved to be cornerstones for Turkey's economy. I now turn to the economic consequences of the compulsory exchange of populations between Greece and Turkey. I'm aware that this issue has been already mentioned in the conference. There have been references to it. Obviously, this was one of the most important issues between Greece and Turkey at the conference, and obviously the exchange of populations has very strong political and social as well as economic dimensions. And I might add that the treaty made little specific allowance for the actual implementation of the population exchange. To be brief, the economics of the population exchange proved to be very costly for both sides. The exchange stipulated that the abandoned properties, or for the most part, the abandoned properties of the Greek Orthodox population leaving for Greece would be taken over by the arriving Muslim population arriving from Greece to Turkey and vice versa. But there was an inherent inequality, unevenness, arising from the numbers. The total number of Greek Orthodox leaving for Greece numbered more than 1 million. 1 million or 1,100,000. Whereas Muslim population arriving from Greece to present-day Turkey numbered a little over 400,000. So there is more than a 2-to-1 ratio. But there is also the fact that Greece had a much smaller population than of Turkey in 1923, 1924. So a simple calculation suggests that the refugees accounted for close to 20% of the population of Greece. The new arriving refugees accounted for close to 20% of the population. But they accounted for less than 4% of the population of Turkey in 1923, 1924. So not only was the Greek side had a much difficult time providing properties for the arriving refugees, but the overall economic burden of integrating the refugees was much greater on Greece. And even though Turkey did not receive much of international assistance in the settlement of the refugees, and Greece did receive some international assistance, the burden was much greater on Turkey. I might add that yes, there were lasting labor shortages, skill shortages for the economy of Turkey during the interwar period, on trade, on agriculture, on manufacturing, but on the whole, the burden, strictly speaking, economic burden was much larger on refugees in Greece and on Greece on the whole. Which brings me to my final comments about the population exchange. It is difficult for us to understand today how the negotiations in Lausanne and the treaty had so little output from the refugees themselves. The people who were doing the actual movement had little voice, very little or no voice at all in shaping the treaty. Of course, historians, political scientists, legal scholars have tried to understand this outcome, and of course, nationalism was the key consideration for both sides, nationalism and economic nationalism. And that goes a long way towards explaining this particular outcome, how the actual peoples subject to this displacement had so little voice in the outcome. But I should add that the international context of the time also played an important role. After both World War I and even after World War II, there were attempts to resolve these ethnic issues by compulsory exchange of populations, and there was eagerness in the early 20s to make the case of Turkey and Greece, the exchange of population between these two countries, as an exemplary case study. So,
Professor Pamuk, we would like your final comment because we're already over time. Thank you.
Yes, yes. It would be best to try to understand this outcome also as part of the international context of the time of the 1920s and more generally of the interwar period. Thank you very much.